They don't break certain criminal laws, normally they don't have to leave for any reason. Other classifications, temporary protected status, that's not as common as it used to be, but a lot of Guatemalans have this status. It runs from 1 year at a time, as they're renewed. Non-citizens with pending applications, let's say someone came over on a student visa, they reapplied for next year, they're waiting to hear back. Well, their visa's expired, but immigration knows they're here and they've reapplied. They technically don't have any papers, but immigration's not going to deport them because they've applied and asked to stay. Undocumented immigrants, these are those who came over without permission, and those who were actually here legally, whose visa expired, were told to leave and chose not to. So we have a lot of white Europeans who are here illegally because they chose to, once their visa expired, chose to stay, even when they were not given permission to. So that's how you become undocumented. Asylees and refugees who come over because they're being persecuted in their home country because of their religion, their race, their political affiliation, sometimes because of the way women are being treated. And some basic rights your kids have, no matter what your legal status, Head Start. K through 12, right to public education. And what's important, I'm going to point out something very important here, that South Carolina schools continually break the law on, despite numerous conversations with Jim Rex's office. They continually ask students for Social Security numbers. That's illegal. You do not have to have a Social Security number to enroll in school, no matter who you are. It's not an exception under the Privacy Act. We have told all people, do not give over a Social Security number, they cannot ask. What schools tend to do now is make up an identifier for you. With identity theft, they really can't afford to have everybody's Social Security number on record.
Right.
So that's a common violation. If your child doesn't have a Social Security number, they don't need one to enroll, period. And also, the school cannot do anything about that child's immigration status. They cannot file immigration. They cannot report that child. Cannot tell anybody that child's legal status. If they do, their federal funds will be taken. So the schools can get some serious trouble over this. All the schools have been issued a memorandum on the law telling them to quit asking for Social Security numbers, but it's been difficult to enforce. But just know that if they ever try to make your child have a social. School breakfast and lunch programs are for all children, as long as they're low income, which I'm sure a lot of your children qualify for. Interpreters and translator materials, any agency that receives federal government funds have to give materials in the person's native language for free. This would be law enforcement, the court, hospitals, legal services, schools, domestic violence shelters, state agencies. And a lot of different places are taking it on their own to meet language access needs just because they have that kind of clientele coming in and they need those services. You may run into agencies claiming that they don't have the money. Oh, yes. You look a little worried.
I told her she's breaking the law. No, I'm serious, because, okay, we certainly serve, I guess, folks. And when you say receive federal money, I think just about everybody receives federal money. And so when I hand somebody who perhaps their native language is Spanish, and I hand them a court order in English, I'm in violation. Is that your interpretation?
It's not clear cut if the order has to be in Spanish, but someone should be explaining it to the family in Spanish so that they understand it.
Okay, but now these families receive this in the mail. This order letting them know who's been appointed as the guardian.
Is there anyone they can call to find out what that says?
My question is though, I know this. If I know this family has limited English or, another capacity, irregardless of that. If their native language is Spanish, and I prepare or have prepared and have a judge sign a court order, and I put it in the mail to them, and I know that, my interpretation is that should be in their native language.
There's no law that says court orders have to be in any other language but English. It's more important to make sure that they understand what's in the court order. And it could be as simple as having someone, a certified translator, put it in Spanish. It just, wouldn't do anything in court because it's in Spanish. But just so they understand it. Or having a meeting with the family with an interpreter and go over it and sign some paper saying, they went over this with me with a certified interpreter. I understand.
I just want you to repeat that to me. There is nothing in the law that says my court order has to be in their native language.
Correct.
Okay, that's all I need to know.
There's nothing that I'm aware of anyway. As far as making sure they understand it, that would be important.
Tammy? Just out of curiosity, it says most agencies receiving federal money. Which ones, what are the exceptions? Or do you know?
It's a little tricky. Some agencies have been found not to have to comply with this, but there would not be any that CASA would be dealing with.
Okay.
When you have court, you're saying materials in their native language, court, what do you think they're getting from court? Orders. We're transcribing our orders into Spanish.
They have to have an interpreter in court to understand
We have the
what's going on.
interpreter, and they usually have an attorney with them.
Right.
And we have an interpreter.
But like at a hospital, if there is materials about emergency medication, that has to be in Spanish. If you go to legal services, if you go and they're trying to terminate your public benefits at DSS, that has to be in Spanish. Certain things of that nature have to be in another language. If it's crucial to their ability to function, which cutting off public benefits would be, a hospital explaining their rights to emergency Medicaid is.
Well, the court hands out for domestic abuse, they hand out that form. So you're saying that they'd have to have one in Spanish.
Well, I know that the way they're getting around it though is the shelters are putting it in Spanish and other languages so that the women understand it. But there's nothing.
No, I'm just saying, but if you're
Right.
not in a shelter, you come down to family court, as I would go if I want to do that, I'm going to be handed the form.
The problem is there's nothing in federal law that says a court has to put any of their documents in another language.
Well, that's wrong then, having court there.
Right.
No, because the court applies to interpreters. You have to have an interpreter in court. This is
It
interpreter.
said, but must give immigrants materials. Okay, now you're saying really the court doesn't have to give materials in the native language.
But law enforcement, hospitals, some of these other places do.
Okay.
I just put it on one slide
Right.
to be more efficient. That's all. The most common immigration status that might apply to the children you're trying to help is called Special Immigrant Juvenile Status, also known as SIJS. And this would give kids a green card. And then from the green card, they can become a citizen. And I have just the basics on here because it's a little complicated. If a child is in family court, they cannot be reunited with their family. The judge has said it's not appropriate to go back and live with those parents or those legal guardians. They've been abused, neglected, abandoned, and essentially the judge has now said, I'm deeming this child eligible for long-term foster care. That's what has to happen. Can't be reunited with the parents. They're in there because of abuse, neglect, or abandonment on the fault of the parents. And basically they're going to end up in long-term foster care unless they're adopted. That's the children that fall under this category.
How about children that end up going to a relative?
If their rights have not been, if they're not going back to their parents, they're eligible.
Okay, that's great.
They're not going back to their parents or their legal guardian, and the relative that's just caring for them is like a foster parent almost. They apply. They qualify. It's basically, you're saying they're being put in a guardianship situation instead of being put in a foster home or with some unrelated foster parent. Yeah, they would qualify.
Even if out of state, if the child, if the
Yes.
relative out of state.
Right. Because this is federal.
Sounds like it.
The judge also has to rule it's not in the child's best interest to go back to the country they were born in.
Right.
Okay.
And typically what will
Okay,
have to
all right.
happen is, in any case, DSS has to do a home study, and in this situation it's a little trickier, but what DSS can do is say the child is from Guatemala. They can call the Guatemalan consulate and ask, what are the conditions like right there? Is it safe for the child to be there? Would it, this child's lived here for 10 years, they don't speak the Hmong dialect, should we send this child back there? They can do simple things like that. And there's also agencies now that are expensive that do international home studies. Or if they know there are relatives there, they can make contact with the relatives and say, would you be able to care for a child? Probably not, considering the family came to the United States. So DSS can get around that and work with that. A child has to be unmarried and under 21. Now, in order to get this, the child should remain under foster care until they're 21 or until they get their green card. We do not want them to emancipate when they turn 18. If they do that and they do not have their green card, they will lose the right to the green card. Period. No way around that part of the law. So until that case is complete, that child needs to stay in there and be educated. No, stay in here, you can get a green card. This is better than being out there and not having legal status. If a child has a criminal conviction, that can keep them from getting this benefit. Usually drug convictions, any serious felonies, sex crimes, anything of that nature is usually a problem and will keep the child from getting a legal status. And that's even an adult. Adult with that cannot get legal status. If it's something minor, it's still worth looking into and seeing if the child can get the benefit. But the main thing we are trying to tell people is make sure the child stays in until they're 21. It may be hard, maybe they hate their foster home, but this is far worth it. So we're trying to make sure they stay in.
With the status, will they be able to get a Social Security number?
Yes, absolutely. Now, the benefits of the child applying for this and actually getting it is they're protected from deportation, also known, the more common term is removal. They can work legally in the United States. They can, the counties that are housing them can get federal money if they receive this status and put it into your group of money from the federal government. Whereas you can't do that if they're not here legally. You get this, you get federal dollars, matching dollars. The child can get in-state tuition for college, get a Social Security number. They get a green card, which means they can live and work here permanently. If they want to travel outside the United States, they can. The law is very tricky on if you're here legally, and you're without a green card, it's hard to travel back and forth across the border. Eligibility for public benefits if they meet certain rules, which could also help out the system trying to care for that child financially. And they can apply to become a citizen if they want to. So there's a lot of benefits here for the child.
Is there a certain age they need to apply?
They need to
Before the
apply
for the green
before
card?
age 18. If they wait until after 18, they're going to have to fast track that application because it has to be done before 21, and immigration is slow. So it could take a full 2 years to get, more than 2 years to get through the process.
Wow.
It is very slow. So they need to apply before age 18.
It says they can, and we probably wouldn't run into this, but we may occasionally, they can, be allowed to travel outside the US. How do they get, are they eligible for a passport?
Yes.
Then?
Mm-hmm.
A United States passport?
If they have a green
If they have
card,
a green
they
card.
would get a passport from their home country, but they can go to the consulate, like there's a Mexican consulate in Raleigh, North Carolina. They can go up there and get a passport from there. If they choose to become a citizen, they can obviously get a United
Right.
States passport. But that's just the main reason they would travel is if they had family in another country.
Right,
But
right.
realistically, they probably don't know them because they've grown up here.
We're all sitting at the table thinking about the same case.
Okay.
So we have how old is Jennifer now?
7?
No, she's not that old. 7. That's what I would think.
Okay.
Her parents are in jail. They will be in jail for a while. All right. So
What are they in jail for?
drugs.
Okay.
Distribution,
I think
big.
they may have like
PWID?
10 more
Okay.
years.
Right.
They're doing probably at 85 for no parole. Yeah.
And we expect that whatever happens after that, they'll probably be removed. after they completed their sentence.
Right,
So going back to the parents is not an option,
right.
alright?
Okay,
We did go to the Mexican consulate and had a home study done on a relative there
good.
that was favorable, alright? But when we got to court, DSS made the recommendation that she go to her relatives in Mexico. Her parents, and I'm pretty sure the guardian.
Her father.
Right, fought for her to stay here, they wanted her to stay here, they didn't want her to go back to Mexico. So the judge said, no, she's not gonna go back to Mexico, do a home study on some relatives in Illinois. So we did the home study through interstate compact on the relatives in Illinois, favorable. She's still in DSS here in South Carolina custody, but placed in Illinois. DSS's plan is to give custody to those relatives, and that's it, we're done,
Okay.
alright? Who wants to talk on this side?
Now we're dealing with the father wanting to relinquish his parental rights is what I'm hearing.
That would actually help her a lot.
It would,
Yes.
but what would be better for her, going through this process and letting her remain in DSS custody? Or
Is it what, I don't know what else.
have her just skip the TPR part because the father, you know, they want to do that and then go straight to adoption, which will benefit Jennifer and give her permanency.
What
here.
you can do, and we're gonna get this in a minute, you can apply for both adoption and SIJS at the same time.
So DSS can do it on their
Right.
end now.
Yes. Absolutely. You can have both those running at the same exact times, not a conflict.
So it sounds like she fits.
She
that
does.
plan.
She's not being returned to her parents, she's under 21, she's obviously unmarried.
She's been told that she should not go back to
Right.
Mexico.
The one thing that the judge will need to do, now that Illinois has the case, that will make it go faster for the immigration attorney, is to write up in an order, this child is deemed eligible for long-term foster care. She's been abused, neglected, abandoned by her parents. She cannot go back with her parents. She is better suited to stay in the United States. The judge will need to put that in an order so the immigration lawyer can put it in a packet and send it off. Otherwise, immigration cannot access the family court records to understand that she qualifies.
So if DSS gives her custody and close the case, that will have to be done in Illinois, which will prolong the whole thing again because those caregivers will have to start at the whole, go back to court to see if the immigration will benefit her.
Well, I mean, if they're already saying she's not going back, I mean,
Right.
it sounds like all the rules are met. The judge just needs to write it in order so an immigration lawyer can start it. Without that order, the immigration attorney really has a hard time starting the process.
So to benefit the child, we should not give the relatives custody. We should just leave them
Right.
placed and DSS retain custody, foster care,
Until
so
all
that she
that's
can meet
resolved.
these requirements
As
still.
long as that otherwise meets her best interests.
Right.
Because if she goes in their custody, then she wouldn't.
But she still doesn't have a social security card, she doesn't have that.
Right. What are the legal status of her relatives?
They are documented.
Okay, either way benefits her then, because they can adopt her if they're citizens and she can get citizenship that way. Either way would benefit her. As long as they're citizens and when the adoption goes through, they can adopt her and she'll become a citizen based on that.
Because we still have jurisdiction,
Okay.
we do the adoption process here, or we would just close the case and wait till they do the adoption part in Illinois.
I would imagine Illinois would pick it up if she's been living there for at least 6 months.
A year.
Unless they have some reason not to. I mean, I don't know why they wouldn't want to pick up the case and the relatives wouldn't want to start the process unless there's something going on. But yeah, either way would work for her. You can do either one. You can open them at the same time and run them.
Okay.
Yeah, here it is. The alternative to SIJS is adoption, and as long as the child is adopted by a citizen before they're 16, and they've been living with that person in legal custody for 2 years prior to the adoption, what happens is after the adoption, the new parents go and file an immigration petition to get her citizenship. And they have to follow through with that. If they don't, it is not automatic. They have to file those papers for her. So either way would get the child legal status. And she would get all those rights. Social security card, everything about it, your driver's license, college. Now, some other possible paths that are usually trickier, most immigrants that come over here without permission don't meet any of these. Have a parent or adult child that's a citizen or a green card that they can apply for your status. A little trickier. Depending on what relative it is, they can apply, but it has to be a close relative unless it's adoption, obviously. It's almost impossible, though, to get this legal status if you came over here without permission and you've been in and out of the country illegally, because what happens is you can get tripped with a 10-year bar, which bans you from the United States for 10 years. So that's why it's so complicated to get legal status. Work, you have unique job skills, education, to go to graduate school. Immigrant crime victims can get legal status. There's UT and the Violence Against Women Act. U visas cover a lot of crimes. You may have a woman who's been raped or a child who's been raped. Possibly the child is being reunited with their parents because they didn't do anything wrong. Well, if the child isn't here legally, they can qualify for a U visa. The U visa says it's a number of crimes, mostly felonies, as long as the child cooperates with law enforcement or the prosecutor to the best of their ability. Do a lineup. Talk to the police about what happened. Testify in court if necessary. If they never find the person that raped her, but they tried to find based on her evidence, it's okay, it's not prosecuted. She still qualifies for a U visa. There has to be severe damage, emotional or physical. Obviously a rape is traumatic. That girl could qualify for a U visa and get legal status that way. Now, a U visa is not as good as a green card because you only get legal status for 4 years at a time, and then you have to reapply. But it's a good for for someone who doesn't have any other options. The T visa is mostly, people think of it as for human trafficking, where women, and primarily women and young children, are being forced into the country as sex slaves. So people that are in that situation can qualify for a T visa, and again, they have to cooperate with law enforcement, tell the truth about what happened. With a T visa, though, a federal law enforcement officer has to believe the charges and sign off on it. Has to submit a form with the application. And the problem with T visas, they're good, except that a lot of times what happens is with human trafficking, let's say the person is from Korea. They've trafficked her over here telling her, you're going to be an actress, and then they turn her into a sex slave. Back in Korea, those human traffickers are harassing her family and threatening to kill them. So if she talks when she's in the United States, her family will die. So a lot of times human trafficking victims will not cooperate with law enforcement. And they will keep their mouth shut and say, no, I wanted to be a prostitute. This isn't true. They have a case in Greenville like that right now where the women will not cooperate. And they are clearly human trafficking victims. So T, depending on your victims, they may not cooperate because they're scared for their family. The Violence Against Women Act is primarily for women and children and men. It's not as common, but men can apply, who are suffering from domestic violence at the hands of either the husband or the father. Can be a stepfather. And the husband or stepfather for VAWA, unfortunately, he has to be either a United States citizen or green card holder. For the other ones, legal status doesn't matter. Violence Against Women Act, he has to be a citizen or a green card holder. So if he's not, they have to go to the U visa and see if they can get domestic violence covered under the U visa. This is not as common in what you see with your kids probably, but it could be other options in case they are reunited with their parents and their parents did nothing wrong. Like you did have a child that was abused by a relative sexually, and now, well, she might qualify for this. Now, what if your child doesn't meet any of these rules? What do you do then? Well, this is the really sad part. Because right now, here's that child's options. Choice A, basically once you turn 18 and a half, immigration starts holding your status against you. And if you're here without permission, time starts running. So this child is now 18 and a half. They've decided they're going to stay in the United States without permission. They're now adults. Here's the reality. They've grown up here, let's say they've been here since they were 5. They've been here over 13 years. They stay here. They will never get a license, never be able to work legally, so low-paying jobs, cannot attend state-funded colleges, cannot get state or federal college aid. They will always be on the run from immigration or hiding out. Even if they marry a United States citizen or a green card holder, doesn't mean they will get legal status. Because if you're in this country illegally and you marry someone that does have status, that is not automatic. Because you have violated the law in being here without lawful presence. What will typically happen is when their spouse petitions for them to become lawfully present, immigration will say, have you ever been in this country illegally? Yes. For how long? And what immigration will then do is typically, unless there's really hardship examples, and having children does not count, a really severe reason that your spouse has to stay here, the spouse that is seeking legal status will have to go back to their home country that they may not know and wait and see if they're allowed back in, sometimes for 2 years or more, and they may not be given permission to come back.
So unless the answer is the truth, a good no, I've never been here illegally, you check yes and say how long, that's bad.
Yeah.
You lie and couldn't. No.
If you lie, that's even worse.
That's even worse.
If you lie, I assure you they will find out.
Wow.
So if that child chooses to stay here after they become 18 and a half, that's the reality. The only thing that would save them is the DREAM Act, and the DREAM Act says it's for children in this situation. Grown up here, came over with their parents, they had no choice, and are now stuck, and they have no way to get legal status. This law is a federal law, it's pending, it's not passed, would give those children the opportunity for legal status if they either went into the military or on their own paid for college, and then they could start the legal process. It would be about 7 to 10 year process to become a citizen. And
But
as
you
long
would
as
have
they
to
have
go to a school that wasn't state funded.
well, if the DREAM Act is passed, they'd have a temporary legal status, so they could go. They would be given temporary legal status. That would be the only option for them. This law has been at the federal level now for 8 years. It is not passed. So, and the reason they started this is because there's about a minimum 30,000 kids in this situation that graduate every year from high school. Now the other option the child has, which is almost as dismal, is leave the United States before they turn 18 and a half. They hit 18, they graduate from high school, leave. Go back to their home country, which means they'll have to get all their documents in order, which means, like, for example, go to the Mexican consulate in Raleigh, get your passport, get your birth certificate, everything lined up. Go back to Mexico. Or, if there's a country like Canada that will take you legally, they can go there and live. Now, most parents don't have their kids' documents in order. The parents have to have their documents in order before the kids can get their documents.
That's what we just talked about.
It can take 6 months to get a passport from the Mexican consulate. So,
If your things are in order.
right. So, we're trying to go out in the community to educate parents, do this now. Your child might need to go back and have your papers in order anyway. Because if you're picked up for deportation, you want to take your child back with you, they got to have papers. So let's say the child says, okay, I'm going to leave. I don't want to be in this country illegally. I'm going to go back to Mexico. Now they have to figure out, how do I get back in?
Right.
Well, the only way they're going to get back in is if they have high skills in the workforce, which means in education typically, unless they're going to do migrant farm work, but that's a lot of people fighting for that job. Or, somehow the laws change. So if they do go to Mexico, or let's say they go to another country that will take them, like Canada, they're on their own. They don't know anybody probably, or their family's poor. How are they going to pay for their rent? How are they going to pay for utilities? How are they going to go to college? How are they going to pay for college? What kind of field are they going to go into? And then they have to petition for the United States to come back years later, and it might be denied. So if these children don't meet any of these qualifications we went through, like SIJS, VAWA, URT, these are their options. That's it. So it's very bleak for these children, and I've met some people who did leave and came back. It was a rough road for them to get through college in another country, but they came back with high job sets and applied for graduate school, entered as graduate students, and are here on visas for school, and hope to become citizens eventually.
And this here is what it would be for regularly for anyone, not just people who grew up here and had to go back. I mean,
This would be for children who have no legal status, that are minors right now. They have to decide what they're going to do before they turn 18 and 18. Because realistically, unless they're in foster care and they meet some of those other laws, there really aren't any opportunities to get legal status. Because once you're here illegally, it's a nightmare trying to get legal status as an adult. Even if you have a child here, they always say, well, you can have a child that's a citizen and they can petition for your legal status. Well, but if you've been here illegally for 20 years, you've been back and forth across the border, which you probably have, 10-year bar. Have to go back and wait. And then you're put on a wait list. My neighbors are from Vietnam. They are citizens. My neighbor served in the military. His family, he has been trying to get his family in the United States. They are on a wait list. They have been waiting for 10 years.
Wow.
He's done everything correctly, filed all the paperwork. They've been waiting for 10 years for his relatives to come over. So there is no guarantee they are getting back in the United States, period. So it's pretty bleak for these children. And keep in mind, we're talking about children that have grown up here, probably never been to their home country, may not speak the English, may not speak that language well.
right.
And more than likely, it's far better that this is the life that they deserve, obviously. Now, these are some common questions that Sean asked me to go over. He said, well, what's the easiest way to ask them these? How can I tell what country the child is from? Just ask them where they were born. That's the simplest, most non-offensive way to ask the child that question without asking their legal status. What country were you born in? And then you'll know from there. And it's not offensive. It doesn't offend them. It doesn't make them think you're trying to find out their legal status. Can we do TPR based on the fact that parents have no legal status? No. No. You have to meet the statutory grounds in the code. If the parents aren't here legally, can we take that into consideration? Because they could be deported. No. Because you don't know if they'll be deported. They might never be picked up. Or if they are picked up, you don't know if they have a defense. A lot of people from Mexico right now are applying for asylum because of gang violence. Not all of them are getting asylum, but a lot of Mexican immigrants in Mexico applying to come over legally are getting it, and vice versa. Ones that are here that are in deportation are applying for that as a defense while they're incarcerated and asking for refugee asylum status. So you never know if they have a defense due to deportation or if they will be picked up. There's been people here for years that never get caught because they never do anything wrong. If the parents are deported, we have an open case, or become involved later, what are the rights of the parents? Same as any other parent. They get notice and they get served. Period. If I'm a GAL, do I have to seek SIJS or any other immigration benefit for the child? There's no duty to, but if you think it's in that child's best interest, as the GAL, then do so. And petition the judge, say, hey, I'm the GAL. I need an immigration attorney to help me. Please let's get one for this child and take it out of funding. But you would have to petition as the GAL for that because the child's not going to be able to do that in court. So that's, if you think it's appropriate, by all means. If they are here without papers, are they eligible for services like therapy and things of that nature? Yes. Especially if you're trying to reunite the parent and child, because I assure you, if you do not, a defense attorney will walk in and say they wouldn't give them services, so how can they get reunited with the child? So, flat out, any kind of, they're eligible regardless of legal status, especially if you're doing reuniting work. Who do we call for language access services? Now, there's the expensive way, which I do not recommend unless it's some really hard dialect. Language Line, they have an internet website, it's a 1-800 number, 24/7 service. They have interpreters for every language in the world. And they charge you a lot of money. That's the best place if you know, or if you have an uncommon dialect. You have call the Guatemalan dialect, the Guatemalan consulate, and say, we have one of your nationals here. I'm trying to help this child. I can't communicate with the child. I need an interpreter. Is there anyone in my area, or can we get on the phone and do this? Can you help me? The consulates are supposed to protect their foreign nationals, and that's what you are unless you have unless you're a citizen. You're a foreign national. Even if you have a green card, you're a foreign national. They're supposed to help their foreign nationals. So you should be able to call that consulate and say, I'm trying to help this child. I need an interpreter. Please assist me. When we had the raid in Greenville where 330 immigrants were arrested, half of them spoke Mayan dialects.
Right.
They called the Guatemalan embassy, the Guatemalan consulate in Atlanta, and they brought people over to interpret. So they will step in. And these are the agencies that do low-cost immigration work in the state. Now, not free, but lower than any other immigration attorney you will find in the state. Emily in Mount Pleasant tends to do more of the SIJS work for children than Glenda. So she would be your first step. I also know a lawyer that does SIJS pro bono. She is on maternity leave at this point, though, so she would not be a good option right now. But if you have a child that you think qualifies for special immigrant juvenile status, I would call Emily and talk to Emily. And Emily is fully bilingual, as is Glenda, Spanish. Those would be your two options, and they can give you a rundown of if they think the child qualifies and what the risks are. But otherwise, there's not like a wide base set of low-cost immigration work in South Carolina. This is it. This is it. They have a Greenville office, and Catholic Charities has a Greenville office, but I will assure you that we have tried to call the Greenville office, and they are not answering the phone. So that's why I did not put their number on here. I take that as a bad sign. You know, you don't answer the phone, I leave you messages, you don't call me back. So that's why I didn't put them up here. I wanted you to get someone that will call you back, which these two ladies will.
Who's on maternity leave there?
Tricia Ravenhorse out of Greenville. And then the other thing I put in your packet is just something that talks about working with mixed families. Mixed families are those where some of the people have legal status and some don't. And just some of the nuances that come about. That's just a little handout you can read whenever you like. But it just has tips for the judge, caseworker, you know, CASA, different people, and it has some of the terms in there we went over. Does anyone have any questions about anything? I'm going to give Sean a pop quiz. Let's see.
Yeah.
Does anyone have any questions about anything?
So, go ahead.
I'm sorry. One of the things I was gonna ask, and this goes back to the services, it's been our experience, DSS cannot get Medicaid for these children.
That's correct.
Because they don't have a social security number.
Right.
And then the services aren't available, they won't provide them without that.
What?
Is there a way around that?
I know.
Aside from just DSS having to.
Eat the cost. That's
Right.
what they're doing.
I know that's what they're
Yeah.
doing.
That's what, we've had several conversations with DSS about this. That's what they have to do, flat out. If they get the child SIJS though, obviously that changes everything.
Right.
But flat out, we've had that conversation and there is no way around it. If they, obviously they can't get Medicaid, that doesn't mean the child can't go to the doctor.
Right, exactly.
You know, things of that nature. They're going to have to eat the cost and take the funds from somewhere else. We've talked to DSS about look for private funding that doesn't have any strings attached and see if you can cover any costs that way. Look for private grants. Look for private donations. anything that can help meet that burden, because federal law says they're entitled to those services.
And this pending DREAM Act, you said that you have to join the military or go to college?
Mhm.
And is there, I mean, you have to join the military for a certain period of time, and you have to graduate from college?
You would have to graduate either, they keep changing the language because it's still pending. The last version said you can either graduate from a 2-year or 4-year college. And they're wanting, right now the military service says 4 years. They may change that, I don't know. But right now the military service will be for 4 years. And a lot of young people would jump at that opportunity. Right now, if you're not here legally, if you're a man, you actually have to register with the selective service by law, but you can't serve. Because if you're not here legally, yeah, well, they're not supposed to tell, but the problem is if you're not here legally, the military cannot run a background check on you to make sure that you're who you say you are and things of that nature. So that's why if you're not here legally, you can't go in the military. Now, are there recruiters that near Texas that break that law every day? And they will put you in because they're desperate for people to join the military. And I know lawyers who've said to their clients, go down to Texas. I know a recruiter that will take you, and they are taking them. Now, I don't know any recruiters here because I've been asked that. I don't know any recruiters here that will take you, but I know in Texas, there's some recruiters down there that do not give.
I have one other question. I heard you say that schools can't inquire about, well, you didn't say that. I think you said schools can't report
Correct.
immigration status of children. And we have been told that particularly DSS cannot ask someone who's involved in an abuse neglect case what their immigration status is. Is that?
The only reason it should come up is if they're trying to figure out if the child's eligible for Medicaid or things of that nature. Or if the person has come in and tried to apply for public benefits. Now, that's different.
I mean, we're dealing with kids who are abused and neglected, so
Right.
we've got kids, either who are in foster care at least temporarily, or who may be removed from their homes. And I know DSS, the caseworkers don't want to ask that question. So generally, I'm the one who asks it.
Well, what they should just ask is what country were you born in? I mean, that's the simplest thing they can do. And if they're trying to find out if the child's eligible for Medicaid.
Right, that's probably, yeah.
And then if
That
they're
should
like.
justify the question, because if they're in foster
That's
care, we're
right,
gonna have to get
right,
Medicaid.
right,
anyway.
exactly.
Right.
And what we find though is a lot of children who actually are born here whose parents are undocumented.
Yeah, that's common too. Yeah, and I should add, with SIJS, if the child gets legal status, the parents cannot.
Period.
And what,
The parents cannot get legal status off the SIJS because the parents are deemed unfit.
Right.
So that does not benefit the parent.
We don't really care. if
In my case, yeah, so the SIJS, that process is done by an immigration attorney.
It doesn't have to be, but it's best because it can be
Yeah.
very complicated,
Right.
and I would not recommend someone that doesn't know immigration law.
Okay. And you gave us names of people
Right.
here in the state.
That's right.
Yes.
That would.
And if something happens and one of those ladies can't do it, let me know. I'll find someone for you.
so, okay, we have mom and dad, who are potentially facing, being deported because of a crime. Their children are in foster care. And let's say they, were born here. So, I think that kind of a situation, whether it's documented or not documented, legal, illegal, whatever the correct terminology would be. But it seems to me like that is a common question that surfaces here in the Guardian office in terms of either just us staffing, or and what happens? What is the appropriate?
Well, if the child's a citizen,
Right.
they don't have anything to worry about.
No, but the mom and dad.
You don't need to worry about mom and dad. They're not your responsibility. They would have to get on their own and seek counsel. If you're only there to represent that child, don't worry about parents.
But I do worry about those parents as I am representing that child, because to me. I
You're
mean,
worried if they get the kids back and they're deported.
No, I'm talking about what if the parents are deported now? The children are in care, but they've lived with mom and dad for 8 years. I mean, that's their life. That's their family.
Well,
Mom and
if,
Then we do the home,
Right.
then we'll do like an
I
interstate
mean,
compact or
if you think it's
inter-country
in
home
their,
study, we call
you
the
know,
consulate
best
there.
interest to be
To
with
be
their
reached.
parents,
Right.
that's fine. You can recommend that to the judge.
That's right, and we send them back to their parents.
Right, you can do that. If you think that's in their best interest, you can send them back with their parents.
But like I said, they've never even been there. They were born here and never left here.
But if for other reasons you think it's appropriate, just like you would for any kid, if you think that's the best decision, then that's what you have to do, regardless of what country the parents are living in.
Does that child have, going out on them, dual citizenship? I don't understand that.
Mexicans do,
Mhm.
not all countries do. You have to apply for it though, it's not automatic. So children who are Mexican, would have to apply for the Mexican citizenship and the United States
United
citizenship.
citizenship.
Mhm.
So if my parents just so happen to have been on a honeymoon or a trip in France, and I was born there, but they were just there on a trip, does that make me,
I won't, no.
okay? There's more to it than that.
Yes, absolutely.
We're concerned.
Absolutely.
I took back the honeymoon and said trip.
There's gonna have to be more than that to get citizenship.
I had, this is an unusual case, but, you know, I could see that it could happen again. I had a case where the mother was, Chinese, and she had been arrested for selling counterfeit goods at flea market along with some other people. And they were holding her in a federal, facility. And while she was in there, she gave birth.
Okay.
And they decided not to try her on the charges and were just deporting her. And my personal position was that we should, and we had no idea what she was going back to or anything. My position was that the child was an American citizen and we should not let that child go. I was overruled not by this administration, by another administration, and told, you know, just to forget it, just let it be. But I had really strong feelings about that. Is there a way to keep that child here if a parent is being deported?
I mean, if you're dealing with that child and you think it's in their best interest, recommend that. I mean, there's no, it doesn't help either way. I mean, if the parents can't use it as a defense. I have children here that are citizens, and the parents can't say, well, you can't deport my parents because I'm here. You would just have to do any other case, recommend that the child stay here, and it'd be up to the judge, obviously. But other than that, there's no law justifying it.
So the child couldn't be forced to go with their parent just because the parent's being deported?
Years ago, immigration did that to Mexican citizens, back in the 70s, to thousands of United States citizen children that made them all go leave. What they typically do is give the parents an option if they know about, not all families say they have kids, they kind of keep it a secret because they don't want immigration to know. But if they do speak up and say they have kids, usually immigration will say, okay, well, do you want this child to go back with you? And if they say yes, they'll put the entire family in what they call a detention camp, jail, together, and wait for them to be deported unless they can get, there's another option called voluntary departure, where you pay for your own trip back home. It's not as bad as deportation, but there's a lot of issues. They will let them do that. But they will normally ask. It's just most people, you know, it's a hard decision for parents to make. Do you leave your kids here, or do you take them with you?
But I know that we talked about the parents' financial situation. That doesn't keep us from not letting the child go back to their, like if they live in a very poor area
I mean,
of Mexico, we can
as
still
long
allow
as
the
you
child
still
to go
think it's
back.
in that child's best interest to be with their parents. Just like here, if you had a child that was living with very poor parents and it wouldn't stop you because otherwise they're fit, same thing. Same thing.
was great. I love it.
That was very informative. Do we know what to do for Jennifer?
What'd she say, something about Jennifer?
Yeah.